All right, I know it's a little earlier than we're to get started, but there's a lot to cover here, so I just wanted to try to see if we can fit it all in. For those of you, most of you I think do know me, I'm Sima Ali. I'm the principal of Ali Law Group, and we do labor and employment consulting and counseling for clients, and do primarily defense litigation for employers. We have it at this space, and we try to do it with one of our, I'd say, partners. Doug and I have known each other a long time, and he owns the Viking Agency. I'm going to let him talk about what he does, but one of the things they do, and I thought it would be helpful to have somebody who can speak to the insurance piece of this. We're a client of Doug's, and the law firm, we use Doug now to do our insurance, and they've been doing our disability insurance, so he can talk a little bit about that, but I'm going to let Doug just give a little overview and about him, and then I'm going to get into PFL again. So.
Oh, well, simple for me, Doug Niffen, the Viking Agency. We do property and casualty insurance, the disability, DBL, and the paid family leave all falls under that. It's a second generation business. We've been in business for 50 plus years. My sister here works with me, Kelly, and we work very hard to do a professional job. It's customer service driven, relationship driven, and feel free to, my card's on the table whenever, at the end, if we have questions, you can ask me questions, or you can always shoot me an email or call if you have any questions about how this is going to affect your insurance premiums.
All right. Yeah, I'm going to try to get through, but what I'd like to do, since we're not a huge group, if there are questions, because there are definitely, the thing is, the way this law is going, and I'll go through obviously more, it's that there's a lot of unknowns. So I think we're trying to anticipate as much as we can. So nobody knows exactly. I think that there's maybe roadmaps and guidelines, but it is something new. So. Feel free to interject with questions, and hopefully at the end, if you have questions for Doug and I, we'll hopefully have time for that. So, first slide. Just, in case anyone doesn't know, hopefully at this point everyone is aware that this law has been passed. It's the New York Paid Family Leave Law. And it is really a landmark, and it is a little bit like of an unprecedented thing. This hasn't happened in a long time, because it is basically an add-on or part of the workers' compensation law. And the reason this law hasn't been changed in probably over 50 years, and so it's a big thing. And when a lot of these other laws you hear about, in terms of discrimination, that's something that I think we've been hearing about a lot in the last 2 weeks. But what's different with workers' comp, and the baseline is you only need one employee for the law to apply. So this applies pretty much to almost every employer in New York State, which is a big deal. And I have clients that they've heard about the Family Medical Leave Act, and they're subject to it, and no matter how many times we've talked about it, they think it just doesn't apply to them. So I'm not sure how to tell you, but I think the thing is, the reason that this is probably even more important is that because it falls under workers' comp, there's also going to be fines and enforcement that are going to be attached to it, which the FMLA is administered by the United States Department of Labor, which, not that that's not an important and big agency, but the Workers' Comp Board, I think everybody is probably familiar with it and has familiarity with filling out those forms. So it's going to be it's supposed to be administered through that agency. Now, the thing that's also, I think, a little bit it's hard to wrap my head around it, and I think it's a little bit interesting, is that it is administered through the Workers' Comp Board, which is really set up for employees' injuries. That's the idea. It's set up because basically, the government, of course, decided that there was going to be instead of people having private right of action to sue for personal injuries related to work, it was going to all be done through this workers' comp, and there's insurance and all of that for, income replacement for on-the-job injuries, but it's for the employee. The paid family leave applies to everybody but the employee. So it's an interesting place that they chose to administer it through that agency, because it's kind of a misnomer. Like employees, I think that as much as it's hard to get out, I think a lot of people, communication-wise, when they hear paid family leave, people have heard about the family medical leave for a long time, but it really doesn't apply to their own health condition or their own injury. So, that's just, it's a very interesting kind of thing. We'll go to the next slide. So just, who is covered? It's really any employer that employs one or more employees on at least 30 days in any calendar year. So that's a low bar. Now, I know this is something not everybody talks about, but it also applies to anyone who employs one or more domestic employees, so people who might work in the home and who work for a minimum of 40 hours a week. Now, in New York, there's also a law called the New York State Domestic Workers' Rights, Bill of Rights. So, I don't know if anyone has people or clients that have people working in their home, they should be in compliance with that law as well. Another question, and something that comes up, I think, for clients, because in this day and age, there are a lot of people that work remotely, that you might have, or you have multiple operations outside of New York. So if you have out-of-state employees, unless the employee works from their home in New York, or anyone working out of state, that employee that works out of state, even if it's for a New York employer, would not be eligible for the PFL benefit. So because their work is outside of the state. Okay, we can go to the next slide. Now, this, I think, just in terms of coverage, I think it's been a little bit more fleshed out in the regulations about who is a covered employee. And right now, what's going to happen is the law literally goes into effect January 1st of 2018. So that is right now the first date that someone can apply for these benefits. So the law goes into effect and someone could literally file for PFL leave January 1st. So when I say January 1st at this point, it's really just when, in order for someone to be able to apply for benefits, they have to have worked this much time before they apply for make the application for the leave, so to speak. So covered employees, or those who are really eligible to apply, have to, if they're full-time, they have to have regularly worked 20 or more hours per week, 26 consecutive weeks prior to the application date. So now, I think if you have somebody who wants to apply for January 1st, the only people that would be eligible at a full-time rate, you're going to look back to, pretty much July 1st at this point. Those are the pool of people that could apply. And obviously, as you move forward, your look back, it's 6 months essentially of full-time employment. And full-time, this is something I hear about too. We do a lot of handbooks and all of that. So, full-time, when you define full-time, it doesn't, in different places it means different things. So, what happens is, if you have somebody who's salaried, who's exempt from overtime, you're not necessarily tracking their hours. So you're kind of, you're making the assumption that they're working more than 20 hours because you don't have any kind of tracking mechanism to see how many hours they might have worked. That's, so you're going to assume somebody is working full-time. Now what's going to happen with this type of law is that you may define in your handbooks, or you may have people that are part-time, and part-time for many people is, less than 40, sometimes it's, it's 30 hours, sometimes it could be, it could be, there is no definition necessarily, it depends on how you define it in your organization. And, and most of the time, I'd say part-time people, not all the time, but I'd say largely are hourly. But what's gonna happen here is 20 hours is clearly not the same as working, a full-time 40 or, around that hours a week as a salaried person. So you're gonna have a pool of part-timers that might regularly work 20 or more hours a week that could be eligible for this full-time benefit. Because part-timers are people who work less than 20 hours a week and have worked 175 work days at their current employer prior to the date they make the application. So 175 work days, I think, really equates to essentially 6 months of employment. I think I'm maybe not doing the math correctly, because I feel like 180 days is half of a year, but you can't, it's not 175 work days.
It's close enough, we'll call it half.
Yeah. So I think it's more like 9 months if you do the math with the work days. But so the reason being, what happens is when they apply for the benefit, the rate that they get, they're going to look at. For full-time, it basically, they are eligible for like the full benefit. Part-time, they're going to look at their average of their compensation over time. Now, let's just say you have somebody who's worked at multiple jobs. Oh, go to the next slide. If they change jobs, the time at the previous employer doesn't count towards qualifications, so it has to be at your current place. So, it's different than unemployment insurance in terms of just work time. It's literally at your job. Now, this is interesting too. Someone who works at 2 jobs, so, someone who works part-time at 2 places, they can actually apply for paid family leave from both. So, great, that's lovely. And employers, now, if you do have, I don't know how many of you have a union, but if you do have union employees and the union benefits or the collective bargaining agreement provides for a greater amount of paid family leave or like the equivalent of paid family leave, then you're kind of excluded from having to offer because you're providing a greater benefit than what's offered by the state. But I don't know how many people actually have that happen because there's not as many unions as there used to be. How will it apply to the qualification period? They can, if they meet the qualification as of 1/1, they can apply, but they basically can apply at any time after also 1/1, once they've reached those numbers. Now this is the part, who's a family member and what are the circumstances. And this is very much broader than the family medical leave. It's much broader than really anything I've kind of encountered in terms of how you think about it. So it's a little bit, again, almost every situation could possibly apply. Now the thing is that's also very interesting is that unlike the family medical leave, when an employee makes an application, the employer makes a determination about whether or not you're going to designate the time as family medical leave. Here, you are just, once you're on notice, now that we're going to talk, they finally released some forms, so you'll start to see what these forms look like and how the process is going to work. But really, once you're on notice as the employer, you're not making the call. You are simply giving them the form, and then this, new tribunal at the Workers' Comp Board is going to make a determination within 5 days about whether or not this qualifies as an instance for this paid family benefit. So, which is a little odd because all you have to do is really provide the paperwork. That's the idea. So what are, potential instances? And then I think you can't, once they're in this period of, contemplation, I guess, and, you can't really take any kind of steps or retaliate against them for making this application. I think that's the idea as the employer. So things like caring for a family member, which includes physical and psychological care with a serious health condition. So that, the physical part I get, but the psychological means, it could mean like emotional support, which is very vague. Now, bonding with a child, but that also basically, it also, pretty much everybody would have maternity, which I think was something you get with short-term disability anyway, arguably FMLA if you had over 50 employees, but now really as pretty much everyone's going to be offering paternity at this point, because that's really what it'll come out to be. To handle certain obligations from a family member's military service, which constitutes a qualifying exigency, I cannot say that word. Family member is also kind of, it's pretty broad, because it means child and parent, but child can be biological, adopted, a foster son or daughter, a stepson or stepdaughter, a legal ward, a son or daughter of a domestic partner, or whom the person stands to parent in loco parentis. So it's like, it's not just, it's really a broad definition of what child is, and the same thing goes for parent. A parent means a biological parent, foster or adopted parent, a parent in law, a step-parent, a legal guardian, or other person who stood in loco parentis for the employee when the employee was a child. So it's kind of broad. And then serious health condition is pretty similar to the FMLA, and that's like an illness or an injury. Someone's in kind of a hospital, or there's continuing treatment, and continuing treatment, there's a healthcare provider, there's some sort of protocol going on. That's something that I think you can recognize. Serious health condition also includes a period of incapacity due to pregnancy. Now this one I think is a little bit, you start to get a little bit different from the FMLA. It's any period in which a family member is unable to work, attend school, or perform regular daily activities due to a chronic serious health condition. Now, it doesn't mean that you have to be under a treatment program. It could be a chronic condition. So that's kind of vague and broad. I don't know, I don't know even if you don't have to be under the treatment of somebody for this chronic serious health condition. So that seems like, again, you're not making the determination, they can just make this application. It also could be for a long-term or permanent period during which a family member is unable to work, and even treatment may not be effective, and they need support. And then finally, there's also a period during which a family member is unable to work and they're incapacitated because he or she is receiving treatment. So, if they had a surgery, or they've had like chemotherapy, and then they're getting recovery for something, that would be, something. Yes.
I have a question. So now under FMLA, if someone goes out on maternity leave, they can claim disability and FMLA. But with this, would it be after the 8 weeks of disability that then they could go on paid family medical leave to bond with the child? Or it wouldn't, like they couldn't do this while
basically, I think there's a you can't get like more than a certain amount total, and it really depends on how you write your policy. So I think basically the way it would work is, I don't think you can, I think they would get the disability, but if you can have the FMLA and the paid family leave run concurrently. So that they wouldn't be able to get like whatever it is, you know, I don't know, let's just assume it's, you know, a regular birth. So they get like 6 weeks of disability, and then if if they wanted to take the 12 weeks of FMLA, 8 of those weeks would be PFL. So it wouldn't be like 8 and then 12, because that's what could happen if
So
you
it'd
didn't.
be after the disability runs out.
Yeah, just for that circumstance,
For that,
because
okay.
you wouldn't want, it's an entitlement they get for that as well. So I don't think they'd be limiting that part, but, I don't know, your
Yeah,
understanding?
you could take it after, so like after the disability ends,
Okay.
they can then take the paid family leave. And you don't have to take it all like a week at a time, like you could take it individual days, like, and it'll be interesting because it'll turn into a little bit of a parenting device in the sense that you may find out January 1, you may get, you know, a guy whose wife had a baby the prior year, and they may decide, well, the wife's gonna stay home 2 days, the in-laws will he can turn to you and say, I'm gonna take every Friday off for the next 40 Fridays for paid family leave. And that could be their device for, you know, taking care of the kid in the first year. So, you know, it doesn't have to be, they have to be in 1-day increments, but it doesn't have to be in a big bulk. They can split it up however they would like to use it, as long as the situation continues.
And how long can that go on for the maternity?
It's 40 days to start out. The first year it's 8 weeks when it rolls out, and then it goes to 10, and then it goes to 12.
12, it caps out at 12.
Okay.
Caps out at 12, but yeah, so they can take the 12 weeks however they would see
Thank
fit.
you.
Okay. Going on with that, so how do you get it so the person goes out on maternity leave, gets that 6 weeks? Now, they're gonna think they're gonna have another 8 weeks. If you wanted to go concurrently, how do we go, we have to state that in our employee handbook, don't we?
Yes, well, you have to state it. So like, with the FMLA, you'd have to state that it would have to be taken concurrently. I don't know that you can, well, they can, I mean, really, they can't, the disability is their personal benefit. Remember, the paid family leave is not for the employee. So the disability is for the mother to recover from the birth. So if she wants that period, that wouldn't be part of the paid family leave. So that's her own entitlement, but it's a lot less money. But if she's saying she don't have to take disability, but if she wants to take the paid family leave instead of disability after the birth because she's caring for her child as opposed to recovering from the birth, there's a higher level of benefits that she'd be eligible for. So that would be up to her to decide. Basically, I think what you as the employer would be obligated to do is just give them the paperwork and they would be able to decide. Now when your handbook, what you want to do is if they're taking a leave that could qualify for multiple things, you want it to be clear that they're not going to be, back to back, that any of those leaves would be taken concurrently, so that you don't have you don't want them to, I mean, it's up to you, but you wouldn't, this way you limit the amount of time the employee is out on the leave. I don't know if that makes sense. Yes?
Can I just go, if you were to do it 1 day at a time, you could almost go 60 weeks, right? You're saying, like, let's say they decide the father's gonna take the
Yeah,
1
you
day
can
off.
take
mother.
1 day for the basic 40 weeks.
Okay, and then you can do that in the first year of the child's life, just because it was born.
Right.
So let's say now you're almost into the next year, when the next calendar year starts, can they take another paid family leave and say that the child has a medical condition or something, and
Yes.
then do it all over again?
Yeah, well, but they have to qualify,
Right.
it depends on
It
how much
has to be
time they
legit.
work.
They
Yeah,
have to be legit, but
yeah,
if his father has cancer the next year and he decides he's gonna take a day to take him to treatment every week, he can do that the following year as well.
And it's 1 paid family leave per calendar year? Like if you had 2 sick,
It maxes
Family
out
members
on the
can't
amount of,
keep doing it.
yeah, it's 8 weeks, but I think I think, I forget now the number, but there's a combined benefit can't exceed a certain amount. But it's annual, but you have to have met the eligibility requirement for that thing. But you could, I mean, even in theory, I mean, somebody, again, it could happen. Somebody could have a situation where, you know, they're caring for their child for something, and then they also have to, all of a sudden something happen with their parent, you know, at the same time. So, you know, I arguably, I guess, again, if they're, depending on how much time they've requested, it's up to a certain point. So, you know, I think you can make an application, but you have to still qualify. It could be for a less, like, if one application's for 2 weeks, another's for 3 within the same year, you can make that application. Okay, so just, again, it doesn't cover an employee's own illness. So, like something like disability, workers' comp is for the employee, and that is not, that's not what paid family leave is about. Okay. Ooh, next one. So if an employee is out on leave caring for a sick family member and the family member becomes hospitalized, does the employee have to return to work? So the answer, probably not, if the employee is still providing care as defined in the regulations, and care doesn't just mean, you know, physical care. It includes emotional support, visitation, assistance in treatment, transportation, arranging for care, assistance with essential daily living matters, and personal attendance services. That's pretty broad. So, you know, they would probably still have a basis to be out if that happens. Now, for the birth of a child, if the mother uses PFL, does the father get a separate bank of PFL time, or is it combined? It's not combined. The father and the mother are entitled to their own 8 weeks of PFL. Now, will you and your spouse be able to use paid family leave at the same time? If you are at different employers, yes. If you're at the same employer, they can deny, you know, both one of you. So you could probably take it separately, but you wouldn't be able to take it at the same time. So that happens.
When you say that, you mean the employer?
The employees.
No employer can deny it?
They can deny it, so that if you know, a couple applies for the paid family leave at the same time, to the same 8 weeks for the reason to care for their child, you could deny one, and you know, but they could still make the application 8 weeks later. So just so you don't lose 2 people at the same time. Okay. Is the paid family leave available for prenatal conditions? For the mother, no, because it's really only supposed to begin after the birth to care for a child. Now, if there's a prenatal condition that requires the pregnant woman to be home and, you know, needs care, then arguably her partner could apply for paid family leave to care for that condition, just, you know, as an FYI. All right, so PFL benefits. Now again, you know, this is just something, and when employees hear this, because the thing is, people are going to use it, because you're, you know, it's out there, people have heard about it, and it says paid family leave. So you know, once people hear the word paid and leave, it's like, I hit the jackpot. I think it's gonna, but what is it, you know, how does it impact you? This is not coming out of the employer's direct pockets, coming out of this insurance money that the employees themselves are really going to be contributing to. There are definitely indirect costs that are gonna be, borne by the employer for sure, but the pay part is really actually coming from, in some ways, the employees themselves, So for the first year, the benefit is 50% of the employee's average weekly wage for 8 weeks, which is, substantial considering, I think, short-term disability is what, like 170
Yeah.
something?
Yeah,
Yeah.
meaningless, yeah.
Well, for some people it's not, but yeah, so that, and it's gonna go up, as you can see, by 2021. It maxes out at 12 weeks, it also increases to 67%, and so it is something, it's also just not going away. This is like going to be, you're preparing for, but it's gonna be something that I think as employers, we're gonna have to be prepared to manage these gaps in employment and manage this process, because it's not, unlike, I think, the wage notices that came out and, there was a flurry of activity and then things were retracted. This is, going to be what is gonna happen in the future. So I think we really have to be prepared for this. With DBL benefits, disability benefits, there's a waiting period, I think, of 7 days before they can really apply for the benefits. With the paid family leave, there is no waiting period for when they're supposed to be eligible for it. And I think, as we discussed, it can be received on an intermittent basis. But I think the lowest increment is a day, which is, thank God. Okay, yay for that. What I think is gonna be weird though, is that there's, it says it's immediate, but this is where I think, I am grappling, trying to figure out how this is all gonna work, because the forms are there, so let's just say an employee, comes and has a situation, and they notify you that, they have to take this leave, so you're gonna put them on paid family leave, I guess in however you're gonna notify or put them on this leave. Now, what happens is, you give them the forms, so once you, as the employer, give them the forms, and then the workers' comp board has 5 days to turn it around and reply back. Now, my question is, what happens if they come back and say, no, it didn't qualify? And now, you have to tell the employee that it was denied, and then what happens to the time, that, like, they've been out now 5 days, does that count towards their PFL that they've taken? Or I would say probably, they can't be retaliated against or like, I'd say punished for thinking that they took the leave. So in effect, if they get denied, I think they're gonna, even though they wouldn't have gotten paid, they've taken a week, and they're, they can't be dinged, it's not gonna be like deducted from their thing. So it's a little bit of a weird process.
Excuse me, they can start taking time off before they get a response from workers'
Yes.
comp?
Yes. Because what happens is, let's just say, in my scenario I just said, that, someone puts it in, you give them the paperwork, what happens is their benefit will be from the date they made the application. So unlike disability, you have to wait 7 days, that there's like a 7-day period before you're really eligible for that disability benefit. This starts day 1. But because of the way it's gonna work, there's gonna be that, like, if it gets denied, they're gonna,
Potentially lose a week of payroll.
they're losing
They're
a week of
gonna
payroll, but
lose
you're
wages.
gonna lose a week of having them there.
Correct.
And then they can, if they apply again, they're gonna, it doesn't deduct from their 8 weeks of, eligibility. So, it's just it'll be interesting. I think we talked about this layering.
Can I ask you a question?
Yeah.
Do you honestly think the workman's comp board is gonna be able to turn anything around in 5 days?
That's what they said they're gonna do? No, well, so that's the other, what are you gonna do? Someone's
take a
out, now
minimum
they're
first.
out, yeah.
Minimum, it's gonna be 30. It'll never be less than that.
Yeah,
You can't-
so
They're
now-
even hiring people, right? They're gonna dump this on them. They would have had to hire another 50,000 employees just to do this.
Now, the one thing for employers that have FMLA, the one thing I will say is that period that they're waiting and maybe, they're gonna also probably apply for FMLA. If it's denied because it doesn't meet the qualifications for FMLA, clearly that period wouldn't count towards any kind of FMLA leave. But if you approve it as FMLA, at least the week that they're taking and waiting would at least be deducted from your FMLA bank, yeah.
Now, I know you said as soon as you hit an application, the clock starts, you could start, but if the timing is right and you can actually plan for it, can you do it in advance? Like if you're doing a paternity leave kind of situation, you know you're gonna be out a certain day, can you do it earlier and then just have a later
I
start date?
think you can pre-approve, I mean, I don't know how that would,
So then you don't have to wait.
You're supposed to give 30 days notice if it's a planned or foreseeable event. The other is if, somebody has a car accident, you gotta go out and start taking care of them. That's the kind of thing where they gotta do the 5-day turnaround. But if it's a deployment for the military and or the birth of a child, it's coming up, you're supposed to give 30-day notice prior to going out.
yeah, it's planned. Okay, so this is the part I remember now. As far as you can't exceed more than 26 weeks of these combined benefits like DBL, PFL, or FML in a 52-week period. So that's where an employee would max out if they do any kind of combined.
That would be per year, right?
Per 52 weeks.
But then in theory, they would become ineligible because they didn't work 26 weeks for the following year, almost at that point,
Well,
right?
they could work 20, like if they come back, they'll have 26 weeks in for 2019. So, you can limit it if you have the FMLA run concurrently, then they really wouldn't get 26 weeks. They could if they took 6 weeks of DBL, 8 weeks of PFL, and 12 weeks of family medical leave, that's 26 weeks. But, you can definitely limit the PFL and family medical leave coverage. Yes.
So when we give them the paperwork, it's their responsibility to submit it to the workers' comp board?
Yes,
And then the workers' comp board will notify us as well as them?
I'm assuming.
It's really it's really a claim that it's going to be administered by your DBL insurance carrier.
Okay.
So whoever your DBL insurance carrier, you're going to fill in the form, send it to them, and then it's their job to negotiate the claim with the workers' comp board and your employee. You should be like stepping out of it at that moment, put it on the insurance company.
But after we give them the forms, we submit it to our disability?
Yeah, you submit it to the
We
disability, you just send it to the disability carrier, you don't like to fax it or email it in, and then you should be able to pretty much wash your hands of it, or the decision-making part. Yeah.
I think a Christmas bonus or a commission, are they gonna divide that by 52 and consider that part of their 1 week pay average?
I think I heard yes, if I remember right from the new, but, and when it says the 50% of it's the average weekly pay in New York State. So right now, they're using $1,305 as the average. So the maximum benefit would be $652 a week, and then it bumps up a little bit.
It's not the employee themselves.
So it caps out at basically $67,000 a year is essentially the cap.
Oh, yeah, sorry.
That's okay. Going back to the timing of when you can reapply. So FMLA, it's within a 12-month period, right?
Correct.
So 12 months from when they go out. So the PFL is just by calendar year?
Well, they can't take more than 26 weeks in a 52-week period. I don't know, you know, it's really, because you look, they have to have worked and done all of this before they apply for the benefit. So I don't know that I think it's a rolling application, because like FMLA is clearly a 12-month period. There is no like annual requirement. All it says is that you have to have worked 26 weeks, 20 hours, or, you know, 175 work days to apply for the benefit. And you can't have more than 26 weeks of a leave period in a 52-week period. So if your application for leave exceeds, you know, the 26 weeks and 52 weeks, then you would be arguably denied. But it's not the same as the FMLA.
Because even someone that has kids like, you know, back to back.
Yeah, so this, I think, this slide, if we go, just hit the answers a little bit, and get a little bit more. So basically, what this says is, for a birth, you have up to 50, you have a whole year from the birth of each child to take PFL. You know, so you could take, so someone has a baby in July of 2017, they have up until July of 2018 to apply for PFL for that child. But you can't apply for the same child twice. Maybe that's a limit, you know. But you can, I don't know, yeah, all these questions I think will be something. So now, many of you probably have paid time off benefits. So with this PFL, employees can choose, but they can't be required to use accrued and available vacation or paid time off so that they can receive their full salary while on paid family leave. Now, if it's a family leave, FMLA situation and paid family leave, the employer can require that they run concurrently. And if an employee is collecting full salary, so they're getting, you know, they have the paid time off or they have some sort of, you know, they're getting their salary, they can't collect their PFL benefits if they're getting their full salary, because it's like they're double dipping. Now, if the employee should choose to use their PTO, their paid time off, during this paid family leave, the employer should request a reimbursement of these PFL benefits, because for the period that they're getting their full salary. Do you know how that is going to work?
No.
No. Okay.
Not yet.
Okay. That's hopefully going to be a form. I don't. Did they have those forms yet? That we have now. Yeah, I think it's just like the certification forms have come out. So the certification forms are, I think, similar to what the FMLA certification forms look like, where, you know, an employee basically has to get some information from a healthcare provider to be able to support their need for the leave. Now, again, what is different is, you know, and you do, you know, they're supposed to comply with HIPAA. It says that in the form itself, but you're giving them the form, and you're not making that decision internally about, you know, whether or not it qualifies. So it's kind of a bizarro thing, I think.
Yeah, but it's also a little easier for the employer, because it's not your decision. You don't have to, you're just passing along the information, and then you can let the insurance company either be the bad guy or the good guy. You know.
Well, it's interesting, but if it's FMLA, they're filling out the form for FMLA. You can't. It doesn't supplant the FMLA. So if someone is applying for a leave that could qualify for FMLA and PFL, you would collect the FMLA paperwork and you would give them the PFL paperwork to submit. Now, there could be a situation, arguably, where you approve the leave as FMLA because it qualifies, you know, or you believe it qualifies. It could be rejected under PFL. I mean, I don't know if that would happen, but it could happen, yeah. And then, I don't know who makes the appeal with I think there's an appeal process. I think the employee would have to, yeah, the employee has to make the appeal too. That's a special board. Okay, so if it's your current practice as the employer to put, when people are on like some type of family leave, basically you're paying for this leave, you should seek the reimbursement. So they said that the mechanism for this reimbursement should be in effect before 1/1. Exciting, which is very close, so we'll see. All right, now, this is important. I think when an employee is out on paid family leave, do they still earn PTO? Basically, no, because they're not actually working. So they won't, up until they take the leave, they're not going, they will, they're going to be accruing the time as they would. But basically, any time that they're off, they are not actually working and they're not, so they can't be accruing. So that's something I think it's important. These are all things when you're writing a handbook or you're putting in your policies, you sort of make the assumption that when people, when you say people accrue a benefit, you're basically assuming that it's based on time that they're actually working. But I think because of all these, there's so many leave entitlements that are out there that I think it's important to really specify and enumerate that accrued vacation means you really only accrue it when you're actually working, not because you're getting, credit for working or you're on an approved leave, so that you're not getting too much time where they're away. So that's important to make sure you clarify that in your handbooks. Okay. Now with health insurance, okay, this is just pretty much similar to family medical leave, that while they're on the PFL, their health insurance, but if they have health insurance, whatever your arrangement with them with health insurance has to remain the same.